distinguished guests, ladies and gentlemen, we will begin our
Distinguished guests, ladies and gentlemen, kindly rise and please remain standing until the end of National Anthem. The ceremonial opening of the legal year 2024 now commence. Procession of the court orderlies.
Procession of the registrars of the courts.
Procession of the members of the Malaysian Bar.
Procession of the State Court Directors.
Procession of the heads of division and deputy heads of division of the Attorney General's chambers.
Procession of the President of the Malaysian Bar, President of the Sabah Law Society, and President of the Advocates Association of Sarawak. Procession of the Attorney General of Malaysia, Solicitor General of Malaysia, Solicitor General 2, Attorney General for the State of Sabah, Attorney General for the State of Sarawak.
Procession of the Judicial Commissioners of the High Court of Malaya and the High Court of Sabah and Sarawak.
Procession of the judges of the High Court of Malaya and the High Court of Sabah and Sarawak.
Procession of the judges of the Court of Appeal.
procession of the Right Honorable Chief Justice of Malaysia, the Right Honorable President of the Court of Appeal, the Right Honorable Chief Judge of Malaya, the Right Honorable Chief Judge of Sabah and Sarawak, and the Honorable Judges of the Federal Court.
Honorable Judges, Your Excellencies, distinguished guests, ladies and gentlemen, please remain standing for the national anthem. Ladies and gentlemen, please take your seats. We now invite Mr. Muhammad Dini Shazwan Abdul Shukur, Senior Assistant Registrar, to lead the Dua recitation.
Assalamualaikum warahmatullahi wabarakatuh. Let us begin our prayers with the recitation of Surah Al-Fatiha. أعوذ بالله السميع العليم بسم الله الرحمن الرحيم الحمد لله رب العالمين والصلاة والسلام على أشرف الأنبياء والمرسلين وعلى آله وصحبه أجمعين. Ya Allah, kami mengangkat tangan memohon perkenan dan rahmat-Mu agar Engkau tambahi kami dengan ilmu dan pengetahuan. Engkau angkatlah darjat badan kehakiman dan perundangan di negara ini sebagai institusi-institusi yang disegani, diyakini, lagi dihormati. We humbly ask from you, O Allah, for all goodness in this auspicious day, its opening and its light and its guidance. And we seek protection by you from its harm and mischief. O Allah, make our gathering today a blessed one, and our disperse thereafter with your forgiveness. Rabbana atina fid dunya hasanah wa fil akhirati hasanah wa qina adzaban nar. Allahumma khtim lana bihusnil khatimah wa la takhtim alaina ya Allah bisu'il khatimah. Wa sallallahu ala sayyidina Muhammad wa ala alihi wa sahbihi wa sallam walhamdulillahi rabbil alamin.
Thank you, Mr. Dini Shazwan. Honorable judges, your excellencies, distinguished guests, ladies and gentlemen, the opening of the legal year 2024 is also streaming live on Facebook and YouTube on the page and channel Badan Kehakiman Malaysia. The Right Honorable Chief Justice of Malaysia, Tun Tengku Maimun binti Tuan Mat, will now preside.
I invite Madam Karen Chia Yi Lin, the President of the Malaysian Bar, to deliver her speech.
Yang Amat Arif Tun Tengku Maimun binti Tuan Mat, Ketua Hakim Negara. Yang Amat Arif Tan Sri Dato' Amah Abang Iskandar bin Abang Hashim, Presiden Mahkamah Rayuan. Yang Amat Arif Tan Sri Dato' Muhammad Zabidin bin Muhammad Dia, Hakim Besar Melaya. Yang Amat Arif Tan Sri Dato' Abdul Rahman bin Sebli, Hakim Besar Sabah dan Sarawak. Yang berbahagia Dato' Ahmad Teriruddin Muhammad Saleh, Peguam Negara Malaysia. Yang Arif Hakim-Hakim dan Pesuruhjaya Kehakiman, ahli-ahli dari Perkhidmatan Kehakiman dan Perundangan, para peguam dari Semenanjung Malaysia, Sabah dan Sarawak, tuan-tuan dan puan-puan yang dihormati. Yang Amat Arif, sepanjang suku terakhir tahun 2023, khususnya pada bulan Oktober hingga ke bulan Disember, kepentingan bahasa Melayu di Malaysia sebagai identiti kebangsaan telah pun dipertegaskan oleh Kerajaan Malaysia dan menjadi tumpuan perbincangan hal-hal kewarganegaraan di Dewan Parlimen. Badan Peguam Malaysia turut menghargai nilai bahasa Melayu kerana ianya dijamin di bawah Perlembagaan Persekutuan dan Akta Bahasa Kebangsaan 1967. Justru itu, Badan Peguam Malaysia bersama dengan Dewan Bahasa dan Pustaka dan Universiti Kebangsaan Malaysia telah pun berjaya menganjurkan pertandingan berbalas pantun undang-undang berperingkat kebangsaan pada 3 hingga 5 hari bulan November 2023 dengan objektif untuk memperkasa dan mempertingkatkan tahap bahasa kebangsaan Malaysia. Meskipun penggunaan bahasa Melayu adalah penting untuk pengamal undang-undang di Malaysia, namun sebagai bahasa perantaraan antarabangsa, demi manfaat para hadirin yang datang dari negara-negara asing pada pagi ini, saya dengan rendah diri memohon izin Yang Amat Arif untuk meneruskan ucapan saya dalam bahasa Inggeris. Much obliged, my lady. I am honoured and privileged to address your ladyship and this esteemed assembly on the occasion of the opening of the legal year 2024. It is my distinct pleasure to do so on behalf of the Malaysian Bar, the Advocates Association of Sarawak, and the Sabah Law Society. My esteemed colleagues Gurveil Singh Sandhu and Muhammad Nazim Madwarin are in attendance, serving as presidents of the Advocates Association of Sarawak and the Sabah Law Society, respectively. I am equally delighted to acknowledge the presence of the Speaker of the House of Representatives, The Honourable Minister in the Prime Minister's Department in charge of Law and Institutional Reforms, the Right Honourable Shari Chief Judge, the Honourable Deputy Inspector General of Police, esteemed members of the judiciary representing various foreign jurisdictions, and distinguished members of the Diplomatic Corps. Also in attendance this morning are our esteemed colleagues from foreign bars, law societies and law associations, and my lady, please allow me the privilege of introducing them. Ms. Lisa Sam, President of the Law Society of Singapore, Mr. C.M. Chan, President of the Law Society of Hong Kong, Mr. Sham Divan, President of Law Asia, Mr. Peter D. Maynard Casey, President of the Commonwealth Lawyers Association, Mr. On Hung Jeng, Vice President of the Law Society of Brunei Darussalam, Isaac Chan, Council Member of the Hong Kong Bar Association, Mr. Hung Xie, Chairman of the International Affairs Committee of the Taiwan Bar Association, Mr. Tran Tuan Pong, Chairman of the International Relations Committee of the Vietnam Bar Federation, Mr. Siva Kumar Kanaga Sabai, Jurisdictional Council Member for Malaysia of the Inter-Pacific Bar Association, Mr. Nitin Thakur, President of the Bombay Bar Association. The Malaysian Bar expresses our utmost appreciation for your presence this morning. My lady, permit me to address some of the events in the preceding year and the aspirations of the Malaysian Bar in facing these events moving forward. And I choose to focus a significant part of this morning's speech circling around the issue of law reform and the strengthening of institutions. At the dawn of 2024, I'm pleased to report the progress and inroads made on the key law reforms that took place in the past year and will reflect on some of the reforms that have not taken place despite strong views put in place by the Malaysian Bar. Firstly, in 2023, Malaysia abolished the mandatory death penalty via the Abolition of Mandatory Death Penalty Act of 2023, the Criminal Procedure Code Amendment Act of 2023, the Penal Code Amendment Act of 2023, and the revision of sentence of death and imprisonment for natural life, temporary jurisdiction of the Federal Court Act of 2023. This was seen as a progressive step towards aligning with international human rights norms and growing global opposition to capital punishment. The Abolition of Mandatory Death Penalty Act of 2023 now eliminates the mandatory death penalty for 12 offenses, including drug trafficking, murder, treason, and terrorism. Additionally, the Act completely eliminates the death penalty for 7 offenses, such as attempted murder and kidnapping. The practice of natural life imprisonment, confining individuals until death, is now replaced with prison terms ranging from 30 to 40 years. Despite these changes, the new legislation still retains the death sentence for the drug trafficking under the Dangerous Drugs Act of 1952, which remains the most common cause of death row convictions. As expressed in many press statements issued in the past, the Malaysian Bar firmly asserts that the death penalty is both cruel and degrading, violating fundamental rights such as the right to life and the right to live free from torture, as enshrined in the Universal Declaration of Human Rights and Article 5, Sub 1 of the Malaysian Federal Constitution, which expressly condemns arbitrary deprivation of life. The irreversible, irreparable, and non-deterrent nature of the death penalty alone warrants its immediate abolition for all crimes. Secondly, since our independence in 1957, the criminalization of attempted suicide has remained a vestige of colonial influence within Malaysia's criminal justice system, resulting in the stigmatization of mental health issues. In 2023, Malaysia finally took concrete steps towards full decriminalization of attempted suicide with the passing of the Mental Health Amendment Act of 2023, Criminal Procedure Code Amendment No. 2 Act of 2023, and the Penal Code Amendment No. 2 Act of 2023. Decriminalizing suicide marks a pivotal stride in prioritizing mental health and well-being, shifting our approach from punitive measures to empathy and understanding for those grappling with mental health challenges. Malaysia has begun to foster open conversations on mental health issues and dismantling the associated stigma on suicide, with the aim of creating an environment that ensures no one is left behind in accessing mental health support. Decriminalizing suicide is progressive, wise, and a humanistic approach on the part of our lawmakers. The third progressive law reform pertains to the criminalization of stalking, which saw its first case being heard in court on 9th of August 2023. And then, on the 15th of December 2023, just recently, my lady, a pre-Merdeka law that punishes men who entice married women was unanimously ruled by the federal court that Section 498 of the Penal Code is unconstitutional, as it unlawfully discriminates on the ground of gender and thereby violating Article 8, Sub 2 of the Federal Constitution. These are developments and reforms which the Malaysian Bar applauds wholeheartedly. Moving on to ongoing law reforms, the Malaysian Bar has welcomed the government's commitment and efforts in looking into the separation of the Attorney General's offices to divide the role of the Attorney General and that of the Public Prosecutor. In November 2023, on invitation by the Parliamentary Special Select Committee on Human Rights, Elections and Institutional Reform, or the PSSC, the Malaysian Bar provided a briefing to the PSSC and submitted a written response in connection with the separation proposal. It is our hope that this reform materializes this year. The sooner, the better, especially seen in the light of applications for discharge not amounting to acquittal in public interest cases. The Malaysian Bar further notes that amendments to the Communications and Multimedia Act of 1998 are being proposed, and the Malaysian Bar has recently submitted a comprehensive paper to Malaysian Communications and Multimedia Commission providing its views premised upon the fundamental rights enshrined in the Federal Constitution, supported by cases in Malaysia as well as in other jurisdictions. There is much to work on, and we hope the Malaysian Bar will be given the platform to further present its views. And in connection to this, we also reiterate our call that the Sedition Act of 1948, the Printing Presses and Publications Act of 1984, and Sections 233 of the Communications and Multimedia Act of 1998 be repealed for encroaching into fundamental liberties of citizens of Malaysia. My lady, the Malaysian Bar welcomes these progressive law reforms that have taken place over the past year and recognizes that throughout the past year, many consultations were conducted by the government on various areas of law and institutional reform, all of which took the form of briefing sessions, workshops, dialogues, call for responses, and submissions in table formats, all of which, again, the Malaysian Bar took pains to participate. While these consultations are good starting points and should be continued, equal emphasis ought to be placed on meaningful dialogue, resulting in mutual outcome, where consultation process is not a mere tokenistic exercise of public engagement. A meaningful consultation encompasses more than just a 1-hour briefing session and a rushed collation of a superficial responses. Engagement sessions must involve several evocative discourse, with points raised by stakeholders being taken seriously and incorporated into the proposed policy and or legislation, unless there are proper justifications why those points should not be incorporated. With so many more other major law reforms in the pipeline, the Malaysian Bar hopes for significant improvements in the consultation process prior to the passing of these laws. My lady, law is shaped not by the privileged few, but by the collective of ordinary citizens in the society that it governs. In support of my call for improvement on meaningful engagements in relation to law reforms, I will highlight 3 points. First, with reference to the much celebrated Human Rights Commission of Malaysia Amendment Act of 2023, which was passed last year in November, the Malaysian Bar observes that efforts should have been made to shield SOHAKAM from direct or indirect influence by the executive. The foundational international principles guiding the establishment of SOHAKAM explicitly emphasize its independence from the government and the necessity to avoid financial control that may compromise its autonomy. However, upon reviewing Sections 7 and 8 of the 2023 Act, it becomes apparent that the Prime Minister is vested with the authority to appoint members of an investigation tribunal and determine the allowances for members of the Sohakam Investigation Tribunal and Commission, which was established under Section 11A of the Human Rights Commission of Malaysia Act of 1999. If these comments appear to be an exercise of the Malaysian Bar to find a cloud behind the silver lining, I make no apology for it. Our concerns have been raised on multiple occasions in the past during a briefing session and focus group discussion. The most recent communication regarding this matter was conveyed in our correspondence to the Law and Institutional Reform Minister, Deputy Minister, as well as Sohakam on the 25th of October 2023, where the Malaysian Bar submitted a full-length memorandum on this point, as well as a whole host of other improvements to the Sohakam Act. These missed opportunities for proper reforms to strengthen the Sohakam institution could have been prevented if an effective consultation process was conducted and serious considerations were given to the views provided by stakeholders. Secondly, the Malaysian Bar has commended the government's decision in approving constitutional amendments to the federal constitution relating to citizenship to address the current discriminatory laws and to grant automatic citizenship to children born overseas to Malaysian mothers but non-Malaysian fathers. However, we have objected to further proposed amendments which would, alarmingly, have the effect of removing existing constitutional protection for some categories of stateless children, leaving them without any constitutional safeguards, thus aggravating the stateless issue in Malaysia. The proposed amendments to Part 3 of the Federal Constitution on citizenship matters, which includes entirely removing Sections 1E and Section 2, Sub 3 of the Second Schedule, provisions which fundamentally protect persons from becoming stateless. Additionally, other causes for concern from the proposed amendment include removing the right of foundlings, including abandoned children, to citizenship by operation of law. The Malaysian Bar is deeply concerned with these proposed amendments that lack justification and empirical data. The detrimental repercussions on the lives of stateless individuals encompassing political, economic, and social spheres are profound. Denial of fundamental rights such as formal education, healthcare, official employment, and access to justice exacerbates their vulnerability. These disadvantages mark them for potential abuse and mistreatment, rendering them susceptible to becoming victims of social ills. Despite immense pushback from multiple stakeholders at various platforms, we note that the government appears to assert their course of action. The Malaysian Bar has conveyed its grave concerns through various correspondence to the Minister of Home Affairs on several occasions last year, and we continue to urge that these proposed amendments be halted. Ultimately, in carrying out our duties in the law reform process, we must be guided by the rule of law and fundamental human rights, not the retention of power. This incident underscores the need for a true and public and transparent consultation with the relevant stakeholders during such law reform process. As for my third point, my lady, beyond providing a platform for diverse perspectives and input, the consultation process also serves as a powerful means for the government to effectively communicate its intentions and purposes to relevant stakeholders. Often overlooked, this facet of the consultation process fosters transparency and understanding between the government and the public, creating a symbiotic relationship built on trust and informed decision-making. So, for example, throughout the latter half of 2023, our local media was consumed with the ongoing conflict in Gaza and the escalating violence resulting in civilian casualties, widespread suffering, and the displacement of countless innocent individuals and families as a result of serious breaches and flagrant violations of international laws. The current Gaza conflict serves as a poignant reminder of the pressing need for Malaysia to reconsider becoming a party to the Rome Statute of the International Criminal Court. The Rome Statute establishes 4 core international crimes. First, genocide. Second, crimes against humanity. Third, war crimes. And fourth, the crime of aggression. And all this represents a crucial instrument in the global effort to combat impunity and hold perpetrators of the most heinous war crimes accountable for their actions at ICC. This reminder relates to my point on the importance of the consultation process. As we may recall, in 2019, Malaysia had signed the Rome Statute, but made a U-turn when, with all due respect, misguided concerns were raised that Malaysia's accession would jeopardize the position of our Malay rulers. A misunderstanding that could have been avoided with a two-way communication by way of proper consultation. My lady, please permit me, as an aside, to mention that the Palestinian Bar has reached out to the Malaysian Bar in recent times, seeking our support as they go through such horrific times. And the Malaysian Bar wishes to hereby declare that we stand shoulder to shoulder with our brothers and sisters at law in Palestine. The Malaysian Bar condemns the atrocities of genocide and war crimes committed by Israel in Gaza, and wholly support the legal proceedings commenced by South Africa at the International Court of Justice. The Malaysian Bar stands ready to render all assistance at the ICJ proceedings by way of intervention, even if necessary, so that no country can use genocide as a defense and an excuse to commit war crimes. As the Malaysian Bar remains committed in constructively engaging with the government and relevant stakeholders for law reform initiatives, my lady, allow me to highlight some of our efforts in the past year. On the 23rd of February 2023, the Malaysian Bar submitted more than 60 submissions with respect to institutional and law reforms to the Minister and Deputy Minister in the Prime Minister's Department in charge of law and institutional reforms. In the interest of time, given that we had prepared 8 volumes of submission which are publicly available on the Malaysian Bar website, I will briefly highlight 2 submissions that we made. First, our case for the repeal of ouster clauses. The Malaysian Bar takes the position that ouster clauses violate the principle of the separation of powers by restricting the judiciary from exercising its crucial role in checking and balancing decisions made by the executive and legislature. Essentially, due to these ouster clauses, decisions from administrative bodies become immune to judicial review. Such clauses are incompatible with the principles of the rule of law and democracy, as they undermine the essential requirement of accountability for administrators and decision makers. In our submission, my lady, the Malaysian Bar highlighted a total of 46 statutes in Malaysia which contain ouster clauses. Following the federal court cases of Nivesh Nair Anak Lelaki Mohan against Dato' Abdul Razak bin Musa, Pengerusi Lembaga Pencegahan Jenayah, and Dinesh Anak Lelaki Tanafil against Lembaga Pencegahan Jenayah, where ouster clauses were declared to be unconstitutional in 2023, and the federal court in the case of Haris Fadilah bin Muhammad Ibrahim against Tan Sri Dato' Sri Haji Azam bin Baki reasoned as follows, and I quote, my lady, "An ouster clause is a self-imposed legislative immunity against judicial scrutiny. What happens if a law is unconstitutional but cannot be challenged because of the ouster clause? Surely, the ouster clause must yield to the supremacy of the federal constitution and not the other way around. And what then if a law or a legal provision, ouster clause or otherwise, is void? Surely, there is a forum to address this. The answer lies in Part 9 of the Federal Constitution and Article 121, Sub 1 of the Federal Constitution, wherein they collectively repose the judicial power of the Federation in the superior courts. This is how powers or mechanisms are determined to exist by inferring them from design and taking them to their natural conclusion. This is all derived from context," unquote. This brings me to the second submission I hope to highlight, amendments to the Article 121 Sub 1 of the Federal Constitution. While amendments are designed to refine the law, unfortunately, what resulted from the Constitution Amendment Act of 1988 is the belief or misconception by some quarters that the courts are powerless to address issues and do justice wherever there is a lacuna in the law, as the courts are confined to merely interpreting and implementing acts of parliament without being able to make and develop common law. Due to such misconceptions, we have cases such as Sivarasa Rahsia against Badan Peguam Malaysia, which relied on the celebrated Indian case of Keshavananda Bharati against State of Kerala to adopt the basic structure doctrine into our local jurisprudence. It is therefore the Malaysian Bar's position that the critical language of the provision under Article 121 sub 1, that is, the judicial power of the Federation shall be vested in the superior courts or judiciary, should be reinstated so as to obviate such misconceptions from recurring again. And in our submission, we had relied on the exemplary jurisdictions such as India, Canada, New Zealand, and Australia. My lady, please permit me to turn to the issue of public interest litigation. The advocacy of public interest litigation can effectively benefit a section of the community or the community as a whole. It is meant to raise awareness of good governance and among the public. Whether such public interest litigation succeed is immaterial. Given the widespread attention that public interest litigation typically attracts, its impact on public perception is ample to underscore the significance of good governance. This serves as a check and balance against executive actions in Malaysia. The role of public interest litigation becomes especially pivotal in judicial review proceedings. This is because confining access to judicial review solely based on personal interests could significantly weaken the court's jurisdictions to oversee administrative authorities. And therefore, the engagement of public interest litigation in judicial review processes plays a crucial role in upholding the rule of law. Despite the boundless benefits of meritorious public interest litigation to society at large, hostility towards these cases in the area of costs remains in 2023, as seen in the Court of Appeal's decision in Faryazat and Co. and another against Pengarah Pendaftaran Negara Wilayah Persekutuan Kuala Lumpur. The risk of having to pay an adverse cost order, and a prohibitive one at that, can have a chilling effect. Many cases are abandoned due to this risk, particularly when there is no monetary compensation involved. For brave litigants with little to lose or organizations with few assets, the risk of an adverse cost order may not be such an insurmountable obstacle. But for the ordinary Malaysians who have limited capacity to manage large and unexpected costs, this cost risk is particularly challenging. Penalizing parties on costs in public interest litigation is counterproductive for the strengthening of institutions and the betterment of nation building. Speaking of costs, my lady, I turn to the rising cost of living, and this pertains directly to income. I take this opportunity to highlight that during the 77th Annual General Meeting of the Malaysian Bar, held on the 18th of March 2023, the Malaysian Bar passed a resolution regarding the remuneration of judges and establishment of a Judges Remuneration Commission. Recognizing that there has been no revision to the salaries of judges since 2015, which is 9 years ago, we view the current state of affairs as unacceptable. As provided in the Commonwealth Latimer House Principles on the 3 branches of government, compensating judges appropriately is a necessary component of judicial independence. Accordingly, an independent commission to periodically assess judicial compensation stands as the most promising approach to realizing the sought-after goals of independence, objectivity, transparency, and consistency. This initiative would be advantageous for judges, those aspiring to a judicial role, and ultimately the general public. On the 14th of April 2023, the Malaysian Bar submitted a copy of the said resolution to the Attorney General's chambers, the Minister in charge of Law and Institutional Reforms, the Prime Minister of Malaysia, and the Leader of the Opposition. The Malaysian Bar will continue to drive this initiative in 2024 because attracting talent to the judiciary, maintaining the talent within the judiciary, and while preserving independence of the judiciary is a benchmark that we all are striving for. In the interest of judiciary, it is also timely for us to reform the composition of and appointments of the Judicial Appointments Commission, or the JAC, and restructure the process of appointment and the appointments criteria of judges to the superior courts. We take the position that there has to be amendments to the Judicial Appointments Commission Act of 2009 to incorporate the participation of all stakeholders in the judicial appointment process. It is also crucial to eliminate the Prime Minister's involvement, particularly in appointing members to the JAC. Given the importance of this reform, further efforts will be made in 2024 to actualize our proposals. The commitment to refining the JAC Act of 2009 reflects our ongoing dedication to fostering a transparent and participatory process in the appointment of judges. Moving on to my next point, my lady. For the benefit of the members of the Malaysian Bar and the legal profession within the administration of justice system, it would be remiss of me if I did not raise the issue of legal professional privilege, which has been a pressing concern in 2023. We highlight two instances where there appears to be a constant onslaught and attempt to erode legal professional privilege. Firstly, the Malaysian Bar condemns the actions of the Malaysian Anti-Corruption Commission and the Inland Revenue Board in their unlawful conduct of attempting to misuse their powers, which disregards the legal professional privilege accorded to the clients of advocates and solicitors. Our criticism was made in response to the Malaysian Bar having received detailed reports from two law firms where attempts to raid their offices were made by MACC, and in the case of one of the other law firms, IRB had also participated in the attempted raid. Despite the fact that the Malaysian Bar had successfully obtained a court order at the High Court as far back as 2018, declaring that privilege is sacrosanct and the IRB cannot be going on a fishing expedition, a decision which was upheld at the Court of Appeal in 2021 and the Federal Court in 2022, lawyers continue to face such unwarranted onslaught. And secondly, it was brought to our attention that Bank Negara Malaysia, when performing on-site examinations of law firms to ensure compliance with the Anti-Money Laundering, Anti-Terrorism Financing and Proceeds of Unlawful Activities Act of 2001, members of the bar have reported that Bank Negara Malaysia is actively soliciting the submission of scanned or copied documents and information in advance of their scheduled examinations, and these requested documents encompass vital materials such as financial statements of the law firms, identification documents leading to the identification of clients, and the transactional documents itself. The Malaysian Bar is unequivocal in stating that privilege is an absolute right and would go so far as to say that it is a constitutional right in ensuring access to justice. Privilege enables clients to repose full trust in their lawyers, sharing sensitive and confidential information in order to receive accurate and proper professional advice. Without privilege, the legal profession would lose its credibility, and confidence in the integrity of the administration of justice would be compromised. The Malaysian Bar therefore continues to be resolute and unwavering in its commitment to upholding privilege. Members of the Malaysian Bar have been reminded to remain vigilant and to zealously defend the sanctity of privilege without fear. On a separate point, the Malaysian Bar has also been looking forward to amendments to the Legal Profession Act of 1976. The Malaysian Bar has concluded consultations with the Attorney General's Chambers on the amendment bill to the Legal Profession Act since mid of 2023. We were unable to see the bill tabled last year, but we are hopeful that with the necessary cooperation from the Minister in charge of law and institutional reforms, the bill will be tabled in Parliament at the next parliamentary sitting. In conclusion, the Malaysian Bar takes heed of your ladyship's comment made when delivering the keynote speech at the 23rd Commonwealth Law Conference of 2023, where your ladyship stated that it is the duty of the Attorney General's Chambers and the Bar to safeguard and strengthen the independence of the judiciary. And on this point, my lady, the Malaysian Bar continues to pledge its role in safeguarding the independence of the judiciary. In 2023, an extraordinary general meeting was convened to pass the resolution on the independence of the judiciary and the upholding of the rule of law, reaffirming the Malaysian Bar's commitment to defend the independence of the judiciary and the rule of law without fear or favor, and to condemn the actions of all those persons who had undermined the independence of the judiciary and violated the rule of law. On behalf of the Malaysian Bar, Advocates Association of Sarawak, and the Sabah Law Society, I wish members of the judiciary and the Attorney General's chambers, as well as members of the Bar, a healthy, fruitful, successful, and peaceful year ahead.
Thank you. And now I invite the Honorable Datuk Ahmad Tariruddin bin Saleh, the Attorney General of Malaysia, to deliver his speech.
May it please Your Honour, Yang Ma'arif Tun Tengku Maimun Tuan Mat, the Chief Justice of Malaysia, the Right Honourable, the Chief Justice of the Supreme Court of Singapore, the former Chief Justices of Malaysia, the Honourable Speaker of the House of Representatives, the Honourable YB Datuk Sri Adrina binti Osman Said, Minister of Law, National Reform, Yang Ma'arif Tan Sri Datuk Ahmad Abang Iskandar bin Abang Hashim, President Khairul Upil, Yang Ma'arif Tan Sri Datuk Muhammad Zabidin bin Muhammad Diah, Chief Judge of Malaya, Yang Ma'arif Tan Sri Datuk Sri Abdul Rahman bin Sibli, Chief Judge of Sabah and Sarawak, Judges of the Superior Court and Judicial Commissioners, Honourable the State Attorney General of Sabah, Honourable State Attorney General of Sarawak, President of the Malaysian Bar, President of the Sabah Law Society, President of the Advocate Association of Sarawak, fellow officers of the Judicial and Legal Service, Your Excellencies, distinguished guests, comrades of the legal fraternities, ladies and gentlemen. Ya Ma'arif, before I begin my speech, allow me to introduce each of the head of division in the Attorney General Chambers, known as AGC. Yang berbahagia, Datuk Amalina Sharmila binti Datuk Dr. Johan, Solicitor General. Yang berbahagia, Datuk Suzana binti Atad, Solicitor General 2. Yang berbahagia, Datuk Manoj Kurup, Head of Prosecution Division. Yang berbahagia, Datuk Nur Mazli binti Abdul Rahim, Head of Advisory Division. Yang berbahagia, Datuk Omar Saifuddin bin Jaafar, Head of Research Division. Yang berbahagia, Datuk Tay Lee Lee, Commissioner of Law Division and Reform. Yang berusaha, Tuan Donald Joseph Franklin, Head of Civil Division. Yang berbahagia, Datin Rosita Ramli, Parliamentary Draftsman. Yang berbahagia, Datuk Dusuki bin Mokhtar, Head of Appellate and Trial Division. Yang berusaha, Tuan Alfian bin Yang Amri, Head of International Division. Yang berbahagia, Datuk Anas bin Ahmad Zaki, Head of Sharia and Harmonization Law Division. Yang berusaha, Tuan Azizi bin Wahab, Director of Management Division. Panjang betul. Assalamualaikum warahmatullahi wabarakatuh. A very good morning. Salam Madani and warm greetings I bid to all of you. May I begin by recording my deepest and utmost appreciation to the Malaysian judiciary, particularly the Right Honourable the Chief Justice of Malaysia, for the privilege and honour to address the esteemed gathering of the legal fraternity on this August and celebrate occasion of the opening of the legal year 2024. This is my maiden opening of the legal year speech as the Attorney General of Malaysia upon assuming office on 6 September 2023. Looking back 3 years ago, Yang Ma'arif, I remember sitting there as the Chief Registrar. How quickly time has passed. It has now become a time-honored tradition and practice that while we welcome and usher in the new legal year, which marks excitement and pleasure for the betterment, we must also reflect and look into the past events and challenges we had to endure through the reminiscent lens of the AGC as an integral component in the administration of justice in Malaysia. Yang Arif, ladies and gentlemen, currently, Malaysia is governed by the unity government, a government that was formed through mutual consensus of different political parties for a common purpose of governing the nation towards excellence and being a people-centric government for all. To echo the words of the Prime Minister, Yang Amat Berhormat Datuk Seri Anwar Ibrahim, the core principles of government are accountability and transparency. I reckon that these principles are not only confined to the nation administration and governance, but they are also relevant to the legal fraternity. It is hoped that these principles will remain intact and could reach greater heights with the new formation of the government. Yang Arif, ladies and gentlemen, in every region of the globe, countries are wrestling with the complex challenges of legal and judicial reforms, including the key question of developing and refining the role and function of the judiciary. Let me reiterate the Beijing Statement of Principle of the Independence of Judiciary, formulated during the 4th Conference of Chief Justices of Asia and Pacific in Perth, Western Australia in 1991. Subsequently, at the conference in Beijing in August 1995, the Statement of Principle was adopted by the Chief Justice from the 20 countries in the Asia Pacific. The statement was signed and subscribed to by the 32 countries in the Asia Pacific region. The general principle laid down in the Beijing Statement are: the independence of the judiciary is essential to the attainment of the objective and the proper performance of its functions in a free society and observing the rule of law. It is essential that such independence be guaranteed by the state, enshrined in the Constitution or the law. And lastly, it is essential to respect and observe the proper objective and function of the judiciary. Former President of the Supreme Court of the United Kingdom, Lord Neuberger, in his valedictory address in July 2017, opined the following, and I quote, "Misconceived attack on the judges undermine the rule of law domestically and the international reputation of the legal system. It is true that the judiciary must respond instantly to such attack, primarily through the written judgment, but we must not forget that an independent legal profession consisting of the relevant stakeholders is equally essential to preserving the rule of law and to safeguard judicial independence. The role of the Attorney General as the public prosecutor, or known as PP, is well established and protected under Article 145 of the Constitution. The prosecutorial discretion of initiating and discounting criminal charges is the exercise of the lawful discretion by the PP, after a careful scrutiny of all the evidence presented by the investigating bodies and also taking into consideration the requirement of the penal laws and procedure. While discharging this constitutional obligation, PP is not bound to furnish any reason whatsoever to any parties. It is therefore pertinent at this juncture to emphasize that the point that the office of the PP must be permitted to discharge its duty well within the confines of the federal constitutions and any written law without unnecessary external interference. All stakeholders must therefore understand and respect the prerogative of the PP and must act fairly to all parties without being selective towards certain matters which will result in sheer wastes of time and resources. This is also true in matters which appear to look frivolous and trivial, as AGC still needs to respond to every matter professionally. Despite having said that, I truly acknowledge and appreciate the role of the Nation Bar in our legal fraternity and have no qualms whatsoever to work in a progressive manner with the Nation Bar on the myriads of legal matters to further enhance and improve our legal system and jurisprudence. On another note, Yang Arif, we are very much aware of the danger of misusing and manipulating issues relating to race, religion, and rulers, which have tendency to disrupt and endanger the peaceful life of the people and national security. I will not hesitate to bring any offender before the face of justice and to take stern action, subject to evidence, of course, to maintain peace and order in this country, including invoking the Citizens Act 1948 and other written law if necessary. Yang Ma'arif, Ya Arif, ladies and gentlemen. As we now ushered with warm the beginning of New Year 2024, I took this opportunity to highlight some of the AGC significance and remarkable accolades for the year 2023, which inter alia includes the following. Firstly, the Malaysian decisive victory at the Paris Court of Appeal, the Hague Court of Appeal, and Luxembourg Court again the claims made by the 8 individuals pretending to be the so-called Sultan of Sulu, Jamalul Kiram descendant. It was a frivolous action and blatant abuse of arbitral and international law process by holding the sovereignty of Malaysia at ransom for an exorbitant sum of money. The victory of nation at the Paris Court of Appeal, the Hague Court of Appeal, and the Luxembourg Court clearly portray that the claim was nothing but a sham arbitration to threaten Malaysian sovereignty. I'm so pleased to announce that on 8 January 2024, the Spanish arbitrator, González Tampa, was controversially ordered to pay US $14.92 billion to the safe complaint heirs of the defunct Sulu Sultanate was found guilty by the Madrid Criminal Court for contempt of court. He was sentenced to 6 months imprisonment and a ban from practicing as arbitrator for a year. Jurisdictional immunities of foreign state bill codifies customary international law on state immunities, which offer general immunities protection to all sovereign states when there are any legal proceedings commenced against the foreign state in the Malaysian courts. With this, it is also hoped that other sovereign nations will reciprocate in return should Malaysia immunity be infringed in their respective domestic court. This bill, without doubt, echoes Malaysia's stance that the immunity of any sovereign nation should always be safeguarded and protected from being abused by any entity. Secondly, the abolition of the mandatory death penalty 2023, which came into force on 4th July 2023, and the revision of sentence of death and imprisonment for naturalized temporary jurisdiction of the Federal Court Act 2023 on 12 September 2023, which brought to the fore the government commitments in protecting universal human rights and upholding principle of restorative justice in the criminal justice system in Malaysia. These landmark amendments also give the Federal Court the revisionary jurisdiction to review the sentence of death and life imprisonment for natural life imposed on convicted person. As of December 2023, AGC has successfully disposed 40 out of 42 applications to review filed in the Federal Court. At the current pace, the intended progress is expected to meet first stride in 2024 to meet the disposal projection in the targeted phases within the stipulated timeline, and this, of course, without compromising the interest of justice. Thirdly, another similar landmark in the year 2023 took place in the promulgation of progressive modern laws to cater for the aspiration of the citizenry and to be made in tandem with the global community. After a holistic deliberation with all the stakeholders, the government decided to repeal Section 309 of the Penal Code, which decriminalized attempted suicide offence. The archaic provision has now been repealed by the Parliament as it is fit and proper to treat those people struggling with mental agony and dilemma as victims and patients rather than offenders. Consequential to the repeal of Section 303, further amendment was effectively made on the Mental Health Act 2001 to refer victims of attempted suicide for examination and treatment of psychiatric hospital and the creation crisis intervention officer to save this victim of attempted suicide, which additional powers of forced entry into premises. AGC also worked closely with the Election Commission of Malaysia throughout the general election of 6 state assemblies and 6 by-election in 2023 in rendering legal opinion and advice as on caretaker government election matters through the setting up of Election Special Operation Room in AGC and State Legal Advisors Office. AGC has also succeeded in securing its own state prosecution building, Besut, Dungun in Terengganu, Seberang in Penang, Pekan in Pahang, Taiping in Perak, Sri Aman in Sarawak, and finally, Tawau in Sabah. Recently, AGC has managed to move the Kelantan State Prosecution Office to a new premises in H. Elite Building in Kota Baru on 3rd December 2023. Finally, as a more little point, a resident DPP has been placed in Kiningau. Yang Ma'arif, Ya Arif, ladies and gentlemen, AGC has succeeded in defending the government interests and has achieved several milestones in public interest cases, which include election petition and suits involving high-profile individuals. The success rate in defending cases is attributed to the government commitments in upholding the rule of law and operating governing machinery in tandem with the spirit of the federal constitutions and other existing laws. The cases, among others. Peter Anthony against Ridwan bin Rubin, a landmark pronouncement by the Apex Court in March 2023, where the federal court ruled that a person who has been convicted for a criminal and was sentenced to imprisonment remains a disqualified person within the meaning of Article 48, 1 and 5 of the Federal Constitution. The federal court explained that the stay order under Section 311 of the CPC does not erase the conviction. It merely operates as to stay the effect of conviction. As any such stay order cannot override the clear prohibitive effects of Article 48 of the Federal Constitution. Selcom Mas sedia berhad against Ketua Setiausaha Kementerian Dalam Negeri. This case served to illustrate the exercise of federal court powers to exercise an arbitral award under paragraph 37(2)(b)(2) of the Arbitration Act 2005 on ground of public policies. In this case, the federal court held that award sum about 144 million is a sum that shocked the conscience of the court, as it is arbitrary, conspicuous, and whimsical. Calling the award as unjustified and exorbitant, the federal court provides a useful guideline as the proper principle for the application of public policy as a ground to set aside an arbitral award. Kartini Farah binti Abdul Rahim against Polis Diraja Malaysia. This case is an example which illustrates the two-step threshold test which must be satisfied at leaf stage in any challenge against the general powers under Article 1453 of the Federal Constitution. AGC has also successfully prosecuted and obtained a criminal conviction against the Pertubuhan Rumah Bonda Kuala Lumpur founder, Siti Bainun binti Ahmad Al-Razali, in the heart-wrenching child abuse case of Bella, which ensued public outcry. She was sentenced to 22 years of imprisonment after being found guilty of abusing and neglecting Bella 2 years ago. Ya Ma'arif, Ya Arif, ladies and gentlemen, I would like to mention that the AGC has already played a pivotal role in ensuring the policy of the government of the day is well translated into legislation in order to achieve the objective intended. In tandem with this, numerous laws were enacted, amongst the highlights as follows. A significant legislative accomplishment was notably the enactment of the Penal Code Amendment Act 2023 and Criminal Procedure Code Amendment Act 2023 to introduce the criminal of stalking and enabling the court to issue protection order against individual under investigation or charged for stalking, thereby fortifying the safeguards for potential victim of stalking. The passing of the Sexual Offences Against Children, which came into force on 11 July 2023 and aims for better protection for children, whereby the terminology of child pornography is replaced with international standard terms, which is child abuse material. At the same time, the Evidence of Child Witness Act Amendment 2023 was also passed to improve the procedure relating to the trials involving children witnesses. The law provides for special hearings to facilitate a child giving evidence and recorded, and also to prohibit any improper question to child witnesses. In November last year, the government has agreed for the National Cyber Security Agency, NACSA, to draft the Cyber Security Bill to provide, among others, the regulatory powers and enforcement of cybersecurity. Cybersecurity plays a crucial role in protecting individuals and organizations and nations from growing threats in the digital world. It also provides the necessary legal foundation to mitigate cyber risk and ensure safety and stability in the digital world. In this regard, AGC plays an active involvement in assisting NACSA on drafting of the cybersecurity bill. Apart from this noteworthy legislative move, another 42 bills have been drafted and tabled, and 898 subsidiary legislation has been published in the Gazette. These legislative measures that have been undertaken were steps taken towards fostering a fairer and more just society. Ya Arif, ladies and gentlemen. AGC has always been central in the negotiation and concluding of commercial deals for the government. Among significant high-impact agreements are, first, bilateral agreement between the government of Malaysia and the government of Singapore on Johor Bahru, Singapore Rapid Transit Link, RTS link. And second, development agreement on the housing project for one military members, one SASA program, one military member, one house program called SASA. It is noteworthy that in 2023, just like the previous years, public-private partnership, PPP project, continue to be the main method of approach for the country development. AGC has continued to be actively involved in high-impact PPP project, encompassing development of public facilities and new highways, which inadvertently will contribute to the nation's economic growth and development in years to come. Ya Arif, ladies and gentlemen. AGC has also played a crucial role in the negotiation and conclusion of bilateral as well as multilateral agreements, treaties between Malaysia and other foreign countries. The conclusion of the treaty between Malaysia and the Republic of Indonesia relating to the delimitation of the territorial sea of the two countries in the southernmost part of Straits of Malacca, and the treaty between Malaysia and the Republic of Indonesia relating to the delimitation of the territorial seas of the two countries in the Sulawesi Sea is historic, as the treaty had been negotiated since year 2005, and AGC had been heavily involved in the negotiation and subsequent conclusion of both treaties. Currently, AGC is leading the negotiation for a maritime boundary between Malaysia and Singapore, including the maritime area surrounding Batu Putih and Tuas, in which both countries have agreed for 12 months expedited negotiation. On this front, I have been mandated to co-chair the joint Malaysia-Singapore Joint Technical Committee and Committee for Boundary Delimitation meeting with my counterpart, the AG of Singapore, while the joint subcommittee is co-chaired by the Solicitor General and her counterpart, the SG of Singapore. I would like to highlight a significant development involving Government of Malaysia in the recent arbitration initiated by the Goldman Sachs Group. Under the arbitration rules of the London Court of International Arbitration, these proceedings stem from several points of agreement under a settlement agreement signed in 2020 between the Government of Malaysia, One Malaysia Development, Berhad, One MDB, and Goldman Sachs. What appear as a resolution to One MDB financial entanglement with Goldman Sachs has morphed into contentious arbitration. In October 2023, the government received an arbitration notice from Goldman Sachs, to which it responded the following month. The arbitration proceedings are now in progress. As we are aware, this case is one of among many arising from the fallout of the One MDB saga, presenting complexities and sensitivities that necessitate effective coordination among the relevant stakeholders in defending national rights. This is obviously important for the Malaysia, and Attorney General is spearheading the action on behalf of the government with the International Legal Council and Council for MDB. It is to be underlined that the government is committed in achieving fair and just resolution to the dispute. Ya Arif, ladies and gentlemen. Proudly, AGC has successfully obtained the approval from the Cabinet to amend the Mutual Assistance in Criminal Act 2002 and has tabled it for first reading on December 2023. The proposed amendment was to improve the provision of Act 621 in providing mutual legal assistance in criminal matters. As the Attorney General, being the central authority for the MLA in criminal matters, it is worth to mention here, throughout 2023, AGC has received 96 MLA requests from several countries, among others Poland, Vietnam, and United States of America, primarily to provide evidence of criminal matters. Malaysia has also made 21 MLA requests to obtain evidence on criminal matters from few countries such as Singapore, Indonesia, and France. AGC has also successfully involved in the working visit and signing of the MLA Treaty between Malaysia and Uzbekistan, headed by the then Solicitor General in Tashkent, Uzbekistan in June 2003. We have also conducted the first round of negotiation for bilateral extradition treaty between Malaysia and Algeria in July 2023, and series of negotiations of the ASEAN extradition treaty in March, June, September, and December 2023. Yang Ma'arif, ladies and gentlemen. Apart from that, AGC was also involved in various significant policy-making committees, namely with regards to human rights and international organization matters. AGC participated in the Human Rights Council session every year, participated in the 61st annual session of ASEAN African Legal Council, ELCO, in Bali, Indonesia, attend the senior officer of Commonwealth Law Minister every 2 years, participated in the session of International Labour Conference and Malaysian European Free Trade Economic Partnership Agreement, MIPA, both held in Geneva and Switzerland. As for international criminal matters, AGC has successfully negotiated and signed the Treaty on National Transfer of Prisoners between the government and the government of Brunei Darussalam on 3rd August 2023. AGC has also actively participated in the negotiation of the draft Comprehensive International Convention on Counterfeiting the Use of Information and Communication Technology for Criminal Purpose. The Special Council on the Implementation of Malaysia Agreement 1963 in subcommittees, where AGC is involved in various negotiation and consultation conducted between the federal government and state government of Sabah and Sarawak on claims to restore the status of Sabah and Sarawak as envisaged in the Malaysia Agreement 1963. AGC also assisted the Federal Sharia Prosecution Department Division to amend several provisions for the Sharia law in the state to curb Sharia criminal offence published on social media to ensure that the proposed amendments are enforceable and comply with the Hukum Syara. Currently, the matter is pending for the Conference of Malay Rulers deliberations. And I'm also proud to mention here that 3 senior officers from the AGC, namely the head of Sharia and Harmonization of Law Division, the deputy head of Civil Division, head of the Constitutional Research Division, has been appointed as member of the Jawatan Kuasa Mengkaji Kompetensi Dewan Undangan Negeri untuk mengubah undang-undang Islam. Yang Ma'arif, ladies and gentlemen. As at 2023, the total number of legal actual officers is 2197, inclusive of 1,524 legal officers in AGC. In 2023, the Judicial and Legal Service Commission has recruited 130 new legal officers, and they have been placed in several divisions in AGC, courts, and various ministry agencies. In 2023, to ensure human capital in the legal and judicial service at the best level, AGC has implemented 131 job rotation involving 600 of 303 legal officers from all grades. This job rotation provides opportunity for legal officers to gain experience and acquiring knowledge in multiple legal disciplines in litigation, advisory, drafting, and judicial, which is useful and beneficial in the long-term career development of the legal officers in the legal and actual service. Before Yang Ma'arif, just to mention, throughout in the year 2023, we have succeeded in disposing a total of 285, 108 criminal cases and civil cases. Yang Ma'arif, ladies and gentlemen, come what may, ultimately our collective aim is to promote justice in line with the legal maxim. Justice should not only be done, but undoubtedly and manifestly seen to be done. This past year had witnessed 3 components in the administration of justice: the judiciary, the AGC, and the bar, working together as a testament of our resilience and tenacity as a legal community. We must therefore send the same message to the public that with the start of the new year 2024, the three components in the administration of justice indeed echo the same aspiration, desire, and vision to uphold the rule of law and to maintain integrity of the legal profession. I must impress here that the best way to maintain confidence in the justice system is to enhance the existing cooperation between judiciary, AGC, and the bar to deliver justice. I do not wish to see decline in the public confidence in any of these components, as the public view us as integrated and not distinct. Hence, the AGC, the judiciary, the AGC, and the bar must come together with one vision, one aim, and join hands to create a conducive working environment towards attaining justice. I'm pleased to mention here that our ongoing and future development plans include relocating existing deputy public prosecutor from the court houses, finally, Yang Arif, and government buildings to separate premises. I'm proud to announce that the AGC will relocate the entire AGC Kuala Lumpur branch from Wisma Chase Perdana to Menara Matrik, Kuala Lumpur, and the Selangor State Provincial Office from the Selangor State Executive Office to the Ideal Convention Centre, IDCC in Shah Alam. In addition, State Provincial Office in Sabah, namely in Hak Datu and Sandakan, through Intan in Perak, Ampang, and Selangor in Selayang. Yang Ma'arif, ladies and gentlemen, with that in mind, allow me to conclude with a pledge on AGC commitments towards ensuring a fair, transparent, and efficient delivery of justice system in Malaysia. AGC role in the justice system is not merely to win at all costs, but to prosecute and conduct case fairly, independently, transparently, based on evidence. I'm thus reminded on my duties with this humble quote from the Quran in Surah Al-Ahzab verse 70 and Surah An-Nisa verse 135, in which Allah subhanahu wa ta'ala, the most gracious, the most merciful, commanded to this effect. O you believers, keep your duty to Allah and fear Him, and speaks always the truth. O you who believe, stand out firmly for justice as witness to Allah, and even though it be against yourself and your parents and your kin. It is worth to mention here that I am humbled and pleased to witness how hardworking my officers and have been throughout the year 2023 in providing comprehensive and valuable in-depth research inputs and a plethora of issues of law, including legal historical background, which deserve recognition in my speech. My officer have remained steadfast in our lines of duty, and we have striven to uphold the rule of law throughout the years. Whenever necessary, this duty also extends to defending the independence and sanctity of the judiciary against any threat. Lastly, I would like to extend my good wishes on this year to all members of the legal fraternity and everyone present for a more peaceful and honest year. With that, allow me to cite one of my favorite poems, entitled Dreams by American poet Langston Hughes. This poem encourages us to have the dream, vision, and aspiration. Hold fast to dream, for if dreams die, life is a broken winged bird that cannot fly. Hold fast to dream, for when its dreams go, life is a barren field frozen with snow. Finally, may I end my speech with the following pantun, Ya Marif. Badah Kehakiman, AGC, and Majlis Peguam, tiga seiring bersama, menjaga prinsip kepentingan awam, sejahtera rakyat untuk selama. Ketua Hakim Negara adil bijaksana, Presiden Bar bijak laksana, Oli menyantun kita bersama, moga silaturahim kekal sentiasa. Wal hidayah wal taufiq wal hidayah. Wassalamualaikum warahmatullahi wabarakatuh. I'm obliged, Ya Marif.
Thank you. The Honorable, the Chief Justice of the Supreme Court of Singapore, Sundaresh Menon, former Chief Justices of Malaysia, Tun Arifin bin Zakaria, Tun Muhammad Raus bin Sharif, the Honorable Speaker of the House of Representatives, the Honorable Minister in the Prime Minister's Department, Law and Institutional Reforms, brother and sister judges, Your Excellencies, distinguished guests, ladies and gentlemen, Assalamu alaikum warahmatullahi wabarakatuh, and a very good morning. Allow me to take a moment to express my gratitude to each and every one of you for your presence today on the occasion of the opening of the legal year 2024. The new legal year brings with it two things. Firstly, it marks new beginnings and journeys. In this regard, I would like to take this opportunity on behalf of the Malaysian judiciary to congratulate all judges of the Federal Court, the Court of Appeal, and the High Court, including judicial commissioners who were appointed in the last year. In particular, I would like to congratulate Yang Amat Arif Tan Sri Abang Iskandar bin Abang Hashim on his appointment as the President of the Court of Appeal, as well as Yang Amat Arif Tan Sri Muhammad Zabidin bin Muhammad Diah and Yang Amat Arif Tan Sri Abdul Rahman bin Sabli on their appointments as Chief Judges respectively of the High Court in Malaya and of the High Court in Sabah and Sarawak. The second thing I think is ushered by the new legal year is remembrance. The celebration of the new year gives us occasion to pause and reflect on all of the chapters that have since closed and to remember those who have completed at least one part of their legal journey. And so I hope it is not too late to wish a happy retirement to all the judges who have retired in the past year. As all the recently appointed judges and judicial commissioners can appreciate, and all the recently retired judges can attest, a judge's duty to preserve, protect, and defend the Federal Constitution is a difficult one, and one that is carried out with little rest. At all times, all judges, even retired judges, remain under the duty to preserve the integrity and image of the judiciary, and those still in service must continue to hear cases impartially, independently, and without an inch of fear or favor. Prior to my appointment as Chief Justice, the judiciary had been mired in a negative perception that, as an institution, we had lost our independence or that our independence was significantly eroded. These heinous connotations owe their existence in large part to the judicial crisis of 1988, a blemish in our history and from which the bruises and scars still remain. More recently, I must share with you that people have been coming up to me from all walks of life to tell me that, in their view, the judiciary has redeemed itself as an independent institution, both in substance and in perception. If this is truly the perception of the public and legal profession, then to that I can only say, Alhamdulillah, praise be to Allah. While I feel a great sense of gratitude and achievement by these kind comments, I cannot help but recall the two important facets of judicial independence. The first of these facets is internal judicial independence. The judicial institution, as well as the judges within it, must be free among themselves to make their own decisions based solely on the facts and the law without any other considerations. Apart from the managerial functions, the four senior-most judges cannot and do not interfere with the decision-making process of any other judge. If the judiciary has been remarked or observed as being independent, then perhaps, as an institution, we have worked hard to be internally independent, not only in fact, but also in perception. That leaves us with the second and no less integral of its facets, external judicial independence. This category is limitless because it deals with external pressures and influences that can directly impact the judiciary's actual ability or perceived ability to decide cases. Certain non-exhaustive examples include, first, intimidation of judges, either in the form of threats, physical harm, lies, or even public humiliation by, for example, attacking the personal reputation of certain judges or their family members. Second, attempting to seek favor with judges, or contacting them directly or indirectly to decide cases in a certain party's favor or against another party. And third, manipulative media reports that unfairly paints the impression of a decision meaning more or less than what it actually is. Those are just some examples of acts that are sometimes intentionally, either directly or indirectly employed with a view to swaying the cause of justice in a certain direction. These are just a fraction of available examples from a bottomless list of anything that can effectively amount to external judicial interference affecting external judicial independence. The judiciary has little to no control over external judicial pressures. In this sense, the judiciary and those who rely on this institution depend on other parties to act responsibly in sustaining and upholding a continuously fair, independent, impartial, and efficient justice system. Be it internal or external judicial independence, they are both inextricably intertwined with the notion of public confidence in the judiciary, and perhaps I can now move on to state my observations on that. Unlike politicians, judges do not and indeed cannot answer to or be governed by political will or popularity. A judge is meant to be an independent, constitutional arbiter of justice between the state and its subjects and vice versa, as well as between subjects inter se. His or her loyalties are apparent in a constitutionally ordained judicial oath taken to protect, preserve, and defend the federal constitution. Since judges do not answer to public opinion, popularity, or sentiments by virtue of them being appointed and not elected, judges then, in the truest sense, are accorded that independence to make decisions based solely on the facts and the law without any attendant fear of the political or social outcome of their decisions. This then begs the question, where does public confidence fit into this equation? What I can say is that public confidence and popularity, though related, do not mean the same thing. A judiciary that enjoys popularity would naturally command significant public confidence. In such a situation, popularity is merely the outcome of strong public confidence. In my view, public confidence in the judiciary is the measure and tool by which judges remain transparent and accountable to the public. Since we are appointed, the public whom we serve by authority of the Federal Constitution has no means of voting us out of office, so to speak. Public confidence in this sense means that the judiciary is mindful of the fact that it is the ultimate servant of the Federal Constitution for the benefit of the public. Because we are appointed, the basis of our foundation of our powers is trust and confidence in the process. It therefore continues to generate an impetus for judges to remain accountable and transparent, and this is obvious in our need to write judgments and to abide by case timelines. Perhaps it is pertinent to highlight that contrary to common belief, judges truly do not carry much in the form of direct power. Take, for example, a criminal case. A judge trying the case and passing a sentence, all things considered, does in effect only make a declaration. This declaration is in the form of a conviction with a resulting sentence. Who ensures the sentence is carried out? Who keeps the sentenced person in jail? Or who enforces the sentence in default of a fine? I think it is the right time to share with you the apocryphal events surrounding the decision of the United States Supreme Court in the case of Worcester against Georgia. It is not the case per se that is the subject of controversy, rather the events that transpired after. Again, even though the events are said to be apocryphal, meaning that their authenticity is doubted, the example itself, real or not, is worthy of reflection. In Worcester, a group of Native Americans had challenged the state of Georgia for enacting a law that required the said Native Americans to be granted a license before they may be permitted to enter the lands which they called their ancestral home. The Supreme Court, presided by Chief Justice John Marshall, delivering the majority judgment, effectively enforced a rule on the sovereignty of the native tribes and held that the Georgian law in question was unconstitutional. Historically, and again, though there is no clear proof to the effect, the then President of the United States, Andrew Jackson, was infamously reported to have remarked against the Supreme Court judgment that Marshall has made his decision, now let him enforce it. While the truth of this statement is suspect, history shows that the Jackson's federal government did not aid in the enforcement of the Worcester against Georgia decision, and the president was himself known to be in favor of expansion of the US territory at the expense of the natives. In fact, the Cherokees were eventually forcibly removed from the ancestral lands, leading to the unfortunate incident known as the Trail of Tears, which resulted in thousands of tragic deaths. The unfortunate historical episode that I just described, in my view, exemplifies the notion that courts are both powerful and powerless at the same time. In the absence of people who can support and carry through judicial decisions, a mere declaration of liability or guilt in itself carries little to no weight. When we put this into perspective, we will come to appreciate that public confidence in the judiciary is meant more for the institution than for its individual judges, though the implication of a lack of confidence can also adversely affect a judge's independence in making a decision, being human beings, for fear of reprisals or in extreme cases, unjust removal. When we consider the occurrence of the 1988 judicial crisis and how the then judiciary was treated with such impunity, the harrowing fears that such events may reoccur haunts to some extent the Hall of Justice till today. When a message is sent that a judicial decision is worth even lesser than the paper it is printed on, it gives the state subject a reason to denounce the validity of judicial decisions. In such a situation, the rule of law, public order, the respect for authority, all enter into a state of chaos. It is therefore worth remembering that any attempt to externally influence the judiciary or to undermine the public confidence in the judiciary is an aberration to the rule of law. In this regard, allow me to address certain aspects within which judicial independence stands threatened, especially from a public confidence perspective, by having regard to certain events that transpired in the past year. In commenting on threats to the judiciary, I must first acknowledge that free speech is central to democracy. Genuine comments and criticism act as positive pressure on elected officials to perform, spur the growth of political will, and motivates judges to remain apprised of recent legal developments, as well as to keep updated on practical knowledge on various fields. What remains unacceptable in a democracy as the antithesis of free speech are concepts such as hate speech, uneducated propaganda, and fake news. Comments and criticisms must be based on some facts and not on lies or ignorance. In the best case, uneducated comments reflect sheer ignorance, and in the worst case, they reflect malice. Allow me to focus on an instance of external interferences with the judiciary, which applies in relation to the judicial role itself, especially in the hearing of constitutional cases. In these examples, I will let you make your own assessment on whether these instances reflect either sheer ignorance or worse, malice. Malaysia is a federation where the primary executive and legislative powers are accorded to the federal government. Recently, the federal court had the occasion to decide two cases, namely Iki Putra bin Mubarak against Kerajaan Negeri Selangor and CIS Forum Malaysia against Kerajaan Negeri Selangor. Without commenting on the substance of the two cases I just cited, they dealt essentially with the question of whether the legislature of the state of Selangor was empowered to pass certain legislation. This is a kind of challenge that is expressly envisioned and catered for by our federal constitution. Unfortunately, these two cases were made out by some parties to be more than what they actually were. These cases had nothing to do with the fact of the pure religion of Islam. They merely sought to re-emphasize the clear demarcation of powers between the Federation and the states. The legislation in question had purported to accord certain powers to the state that were not supported by the state list, and the two cases would have been decided using the same principles if the state legislation in question had dealt with any other matters not affecting the administration of the religion of Islam or the Sharia courts. The comments by certain irresponsible parties are targeted at painting the picture that the judiciary has an agenda or motives to either eradicate Islam in this country or an agenda to remove the Islamic legal system in Malaysia. Apart from manipulating these cases for their own gain, what these parties fail to mention is that by clearly interpreting the federal constitution and defining the powers of parliaments and the state legislatures, the federal court ensures the continuous and steady application of Islamic law in the states because it guarantees that even parliament cannot erode it. The comments in relation to the PICC Putra and CIS forum decisions are far and wide. In some part, these comments unjustifiably question the personal faith of certain judges or even their motivation for deciding as such. In other aspects, such comments incite hatred and ill will among the public against the judiciary or the fear of perceived distorted outcome of such decisions. In certain other aspects, large crowds are mobilized and their presence is used to intimidate the judges. The examples indicate how the judicial independence is eroded and how public confidence in the judiciary is impaired. There is another example which relates to how the judiciary is unjustifiably painted as the villain for the actions or inactions of another body in the justice system. In particular, in the recent past, including last year, the public prosecutor made the decision to withdraw criminal charges against certain high-profile individuals. These decisions were not particularly received well by the public, but a large part of the blame was put on the judiciary for making the only available consequential orders upon the withdrawal of such charges. Under Article 145, Clause 3 of the Federal Constitution, the Attorney General, who is also the public prosecutor, has the discretion to institute, conduct, or discontinue any proceeding for an offense other than before a Sharia court. When the public prosecutor decides to withdraw charges, the courts only have one of two very limited consequential options. Depending on the facts, these two options are either granting an order of discharge not amounting to acquittal, popularly called DNAA, or a discharge amounting to an acquittal, which can be called a DAA. The courts cannot turn around and insist to the public prosecutor that a charge remain. Each of them, the judiciary and the public prosecutor, have their own constitutionally demarcated constitutional functions, and both must be adjudged fairly for the exercise of their powers to the exclusion of the other. And yet, when a charge is withdrawn, the judge making the only available consequential orders is painted as corrupt, sometimes as incompetent, or sometimes both. What the public fails to understand is that the person responsible for that decision is the public prosecutor and not the courts. It is often the courts that are chastised for such decisions, and this erodes public confidence in the judicial system. Having stated these examples, we must ask, how can we ensure the continued protection and integrity of the justice system and preserve public confidence in our judicial institution? Beginning with internal judicial independence, it is my view that a judge must continue to hear cases without fear or favor and without any motivations, hope of reward, or any bias. In particular, I would like to remind myself, as well as my sister and brother judges, about the crucial significance of stare decisis, or the doctrine of judicial precedent. Courts lower in the judicial hierarchy must remember to abide by precedents set by higher courts. The federal court, being the apex court, must continue to remember that it cannot depart too easily from precedent, especially so if a previously decided authority is questioned not so long after it was decided. The federal court cannot afford to be inconsistent, as that interferes with the public who organizes their affairs upon legal clarity and certainty. In this regard, the individual opinion of a judge, so to speak, is irrelevant on account of stare decisis. Even if a judge or court believes a decision of the higher court to be wrong, he is under an obligation to abide by it. It would be for the parties to bring that case to the higher court to argue in favor of departing from the previously established precedent if the circumstances so warrant it. Certain concepts have recently been well settled into our law. One of these concepts is the doctrine of the constitutional supremacy in Article 4, Clause 1, which stipulates that certain features of the federal constitution are incapable of being destroyed even by constitutional amendment. While judges are free to express their differing opinions on what those integral features are based on the cases that come up before them, I think it is not open for judges to dispute the existence of the concept itself. In this regard, stare decisis must not only be observed by judges but by all officers of the court. This includes advocates from the bar and the public service. In recent times, from my own observation in court, I have noticed a trend from a minority of both such advocates who cite cases without acknowledging that those cases or principles that they have cited have been expressly overruled. Other times, these advocates advance untenable propositions that stemmed from a selective, dishonest, or warped reading of earlier cases. These violations happen in all sorts of cases, but they are particularly glaring when they happen in constitutional cases. In any event, when it does happen, it throws judges off, as certain propositions appear more convincing than they should be because they are articulated selectively, yet disingenuously. I think it goes without saying that advocates, especially the senior ones, know that this is not the candor and standard of professional courtesy expected of them, and as such, this practice deserves to be called out and must be stopped. And speaking of seniority, there is a trend in Malaysia, like in many Commonwealth nations, that senior advocates are accorded a greater amount of respect and patience by the court. While this makes sense and it is fair considering that such an advocate has earned his or her trust and reputation with the bench, I would think that regardless of seniority, all advocates deserve an equal chance in court. In any event, leaving aside the minority of advocates who flaunt ethics, I must commend the majority of the better advocates from the bar and the AGC who stand by the principles of ethics expected of the legal profession and whose compliance is impeccable. I would also like to commend all judges and judicial commissioners, as they have been hard at work in spite of all trials and tribulations the judiciary faced in the last year. That said, judges are human and are open to humanly pitfalls such as fatigue and saturation. For these reasons, we routinely rotate our judges so that those hearing civil cases swap to the criminal courts and so on. The judiciary also carries out routine training and refresher courses so that our judges remain updated on recent and emerging trends. In this regard, the judiciary would like to especially thank the Minister in the Prime Minister's Department, Law and Institutional Reform, Datuk Sri Azalina Osman Said, for her unrelenting support for the long-pending establishment of the Judicial Academy. This academy crucially provides pivotal training to superior court justices, thus enhancing the overall caliber of our judiciary. In terms of judicial work, one important area that bears mention is the commercial courts. In a time where our economy is on the downturn, the commercial courts have been working hard to ensure that commercial disputes are resolved quickly but fairly. The importance of commercial courts cannot be understated because these courts, along with the overall impression of an independent judiciary, boosts investor confidence and trust in the Malaysian judiciary. In that respect, a large bulk of our commercial litigation, including construction law, is centered in Klang Valley. The Malaysian judiciary would like to applaud the Government of Malaysia for previously allocating funds to equip particularly the Construction Court and the Kuala Lumpur Commercial Courts. But as time progresses, technologies develop and the need for more judges arises. We would like to humbly invite the government to consider increasing funding for these courts, in particular to entertain the idea of enhancing the structure of such courts so that they can continue to compete and remain on par with international standards and international commercial courts. The Malaysian judiciary is significantly complemented by our ever-growing alternative dispute resolution ADR scene. These ADR mechanisms significantly help reduce the judiciary's caseload without compromising access to justice. Specifically, I would like to home in to one feature of ADR, i.e. mediation. In view of the burgeoning caseload that is inundating the Malaysian superior and subordinate courts, mediation has now become an important medium to cope and deal with these cases, and ideally, hearing of cases via trial must be the last resort. There are generally two modes of mediation, that is to say, pre-action mediation as well as court annex mediation, which are catered for in Rules of Court 2012. It is mandatory for all running down cases to undergo mediation. The necessity of other cases to undergo mediation is at the discretion of the judge, depending on his or her views on the suitability thereof. By virtue of the current volume of cases commenced in the court, there is a critical need to now intensify the usage of court annex mediation. In other words, at case management, all judges must duly consider why each and every case should not be mediated. Unless absolutely unsuitable, I take the position that cases ought to undergo mediation. Additionally, judges must also be part of the mediation process, sitting as the mediator, and should not shy away from the process. This is because judges are in the best position to persuade parties to resolve their dispute amicably by means of facilitative or evaluative mediation. The Court Annex Mediation Committee is tasked to oversee the implementation of the same. Unlike other countries, such as in England and Wales, there is presently no requirement for parties to undergo mediation prior to commencing an action in the Malaysian courts. As such, the judiciary strongly feels that the time has arrived to consider the implementation of pre-action mediation through the pre-action mediation protocols. Towards this end, the Court Annex Mediation Committee is further tasked to study and revert on the same soon as possible. This should include requisite proposals on amendment to the relevant statute and/or rules. In this vein, I would also like to congratulate the Malaysian Bar for establishing the Malaysian International Mediation Center, MIMC, which will be launched later this afternoon. This effort signifies the Bar's commitment to mediation and ADR and has the Malaysian judiciary's full support. On the topic of internal judicial independence, competency, and efficiency, I would like to sincerely believe that the judiciary is doing its level best to ensure that the high standards expected of us are maintained. That leaves us with external judicial independence. Going by the examples I have set earlier, the number of things the judiciary can do in the face of attacks is limited. In this regard, and as has been stated on innumerable number of times before, the other actors in the justice system play a crucial role. The Bar Council has of late been very supportive of the judiciary, and the Bar has also played an important role as amicus curiae in many important cases that were argued last year. We hope that the Bar can continue to maintain such level of support. The Attorney General's Chambers, or AGC, has also been a friend to the Malaysian judiciary. In particular, the present Attorney General, Datuk Ahmad Tariruddin bin Muhammad Saleh, was not too long ago Chief Registrar of the Federal Court. He has, as Attorney General, played a very integral role as a bridge between the judiciary and the executive by ensuring that certain fundamental matters, such as legal development and budgeting issues, are brought to the ears of the executive. The judiciary remains ever thankful to the Honorable Attorney General and the AGC under his able leadership. Having said that, we can understand that unlike the Malaysian Bar, at times the AGC cannot always come out so strongly in support of the Malaysian judiciary. The reasons for this, as we can acknowledge, are twofold. The first reason is that the Attorney General is the principal advisor to the Yang Pertuan Agong, the Cabinet, and all its ministers. Where there is a constitutional crisis or constitutional issue, the AG and the AGC will find themselves in a very precarious position of having to defend the government and advise on the outcome of judicial decisions, while at the same time defending the judicial institution. It is a daunting task that is easier said than done for anyone who stands in the shoes of the AG. Secondly, the AGC very often represents the very litigant against which the Malaysian judiciary acts as a check and balance. Sometimes the AG, being the public prosecutor, is also directly the litigant in court. Nonetheless, I think there is a delicate balance that can be maintained. The AGC can continue to carry out its functions to preserve the integrity of the judiciary and the overall justice system by taking appropriate penal measures against those who unfairly attack the justice system. For instance, as the guardian of public interest, the AG is arguably the only legal person in the country who can initiate contempt proceedings against a person if he makes scurrilous comments attacking the judiciary in respect of decided or presently argued cases. Apart from that, everyone, including the Bar, the AGC, politicians, members of government, and the general public, must make every effort to remain informed. Our grounds of judgment are available for public scrutiny, and everyone is welcome to make fair comment on them. No person should be allowed to use the judiciary and the justice system as leverage for their political or non-political attempts. Recently, the Right Honourable, the Prime Minister of Malaysia, Datuk Sri Anwar Ibrahim, is reported to have reminded politicians not to politicize the issue of the constitutional challenge proceedings and, in effect, not to turn the case into something more than what it was. This reminder by the Prime Minister to politicians is welcome, and we hope that all persons, politicians and activists can follow this line of thinking. The judiciary expresses its gratitude to the Prime Minister for making this statement, as it effectively serves as a call to respect the independence and integrity of the courts. From the standpoint of the judges, all members of the public alike must learn to draw the line between legitimate criticism of judicial decisions on the one side and on the other side engaging in acts or indulging in words that harm the integrity of the judicial institution on the whole. There will always be amongst us the more recalcitrant persons whose nature is to cause trouble. In respect of these very few people, it is the judiciary's hope that all actors involved in the justice system can take the necessary legal action as well as work to educate the public. This hope extends not only in relation to the Bar and the AGC, but to all sectors of our public, including enforcement bodies, activists, and religious institutions. To conclude, I would state that as an institution, the judiciary shall continue to do its best to protect, preserve, and defend the Federal Constitution and adjudicate cases fairly in accordance with justice without fear or favor. We hope never to flinch in the face of adversity and all the brickbats thrown at us. The judiciary shall remain open to working with all institutions that share these goals of enhancing access to justice and the rule of law. And in this regard, we would like to acknowledge all the local and foreign bodies and institutions that engage with the judiciary in the last year towards improving legal understanding and competence, both at the judicial level specifically and the general level. I would like to end by thanking each and every judge, judicial commissioner, as well as judicial officers who have continued to work hard in the last year. This expression of gratitude also extends equally to all our support staff, including our IT technicians, court clerks, secretaries, security personnel, librarians, assistant registrars, commissioners for oath, cleaners, and everyone else I might have unwittingly missed. Each and everyone plays an important role. With that, I wish each and every one of you a very happy New Year. Thank you.
Thank you, Right Honorable Chief Justice.
Honorable judges, Your Excellencies, distinguished guests, ladies and gentlemen, we now present to you a multimedia presentation entitled Reminiscing Memories of 2023.
Honorable judges, Your Excellencies, distinguished guests, ladies and gentlemen, we have now come to the end of the proceeding. The Malaysian judiciary extends its deepest gratitude to all parties who have made this proceeding a successful one. Please remain in this hall until the next announcement to leave the hall is made.
Please rise.
Announcing the departure of the Right Honourable Chief Justice of Malaysia, the Right Honourable President of the Court of Appeal, the Right Honourable Chief Judge of Malaya, the Right Honourable Chief Judge of Sabah and Sarawak, and the Honourable Judges of the Federal Court. Honourable Judges of the Court of Appeal,
Honorable Judges and Judicial Commissioners of the High Court of Malaya and the High Court of Sabah and Sarawak. The registrars of the courts. Ladies and gentlemen, you are now cordially invited to luncheon at Putra Hall A, concourse level. Thank you.